My dirtiest job I ever had was 4 summers working in a slaughterhouse.
Yes.
I always wanted to go back to college.
Yes.
I couldn't wait to get out of there. It was unbearable. It was dirty. It was hot. Things I did were unimaginable, and I wouldn't even start to repeat them. Then came a case before you called Agro-Processor Company versus NLRB. At least a third of the workers, Judge Kavanaugh, in our nation's slaughterhouses are immigrants. It stands visits to Iowa or Illinois, probably Delaware, you pick it. You're going to find a lot of immigrants doing these miserable, dirty, stinking, hot jobs. Many of them are undocumented. The work is low-paid and dangerous. And as the GAO has noted, immigrants are pressured not to even report injuries on the job. Agro-Processor's case was a notorious meatpacking company owned by Shalom Rabashkin, who was convicted of 86 counts of fraud and money laundering in 2009. His 27-year sentence recently was commuted by President Trump. Agro-Processors had at the core of its business model the exploitation of undocumented workers. Half their workers, almost 400 of them, were not authorized. Workers alleged the company fostered a hostile workplace environment that included 12-hour shifts without overtime pay, exposure to dangerous chemicals, sexual harassment, and child labor. A truck driver at Agro-Processor's Brooklyn warehouse told reporters, quote, "We were treated like garbage, and if we said anything, we got fired immediately." Judge Kavanaugh, you bent over backwards to take the company's side against these workers. In a 2008 D.C. Circuit case, Agro-Processor versus NLRB, your dissent argued that this company's workers should be prohibited from unionizing because they did not fit your definition of an employee. To reach this conclusion, you imported a definition of employee from a totally different statute. You ignored the plain language of the controlling statute, the National Labor Relations Act, which has a broad definition of employee, as well as binding Supreme Court precedent. The majority in this case, and you were a dissenter, the majority in this case noted that their opinion stuck to the text of the National Labor Relations Act and to the 1986 Immigration Reform and Control Act, which did not amend the National Labor Relations Act. They said that your dissent, these other judges said about your dissent, would, quote, abandon the text of the controlling statute and lead to a, quote, absurd result. The majority in this decision included 1 Republican and 1 Democratic appointed judge. Judge Kavanaugh, you claim over and over again to be a textualist, to be carefully weighing every word of a statute.
Yes.
So why did you go out of your way to interpret the word employee in a way that benefited this horrible business and disadvantaged these exploited workers? Why didn't you stick to the plain language of the controlling statute and the binding Supreme Court precedent?
Because the Supreme Court precedent compelled me to reach the results that I reached. And here's why, Senator. Let me explain. The Supreme Court had a case in 1984 called the Shurtan decision. And the Shurtan decision considered the interaction of the National Labor Relations Law Act and the immigration laws. And what the Supreme Court did in Shurtan is had this question and said it is at that time permissible to consider an immigrant unlawfully in the country as an employee under the National Labor Relations Act. And in Part 2B of the opinion, you have to read Part 2B of the opinion, of the Supreme Court's opinion. If you read Part 2B of the opinion, the court then goes on to say, and because the immigration laws do not prohibit employment of people unlawfully in the country, and makes clear, the Supreme Court makes clear, this is when it's being considered in Congress in 84, it ends up in the 86 Act. The court makes clear, as I read Part 2B, and I think I'm correct on this, that if the immigration laws did prohibit employment of someone here unlawfully in the country, then that would also mean that they can't vote in the union election. So what I was doing there, Senator, it's all about precedent. I read that, and my opinion, if you look at the dissenting opinion, I really parsed this very carefully, and I went deep into this case. So I went back and pulled from the Shurtan case, I went and asked for the Marshall papers, Thurgood Marshall papers from the library, to read all the memos that went back and forth among the justices in the Shurtan case. I cited the oral argument to make sure that what I was reading in there was actually reflected what had been going on in the Supreme Court. And it is quite clear from the oral argument, they were aware that the immigration law was about to be changed, and they were aware of the interaction between the labor law and the immigration law. So I think I stand by what I wrote then, and I think I correctly analyzed Part 2B. Now, Senator, if it ends
out of time here.
I know, but if it ends, if the Supreme Court's Shurtan opinion had ended at Part 2A, 100% would agree with you, and my decision would have been different.
Well, let me just say
if you read
this.
Part 2B, I think you see.
You said earlier today you don't get to pick and choose which Supreme Court precedent you follow. The majority in agro-processor's case was following Supreme Court precedent. In the Shurtan case, the Supreme Court, a 7-2 decision, said that undocumented immigrants are employees under the National Labor Relations Act. I quote, "Since undocumented aliens are not among the few groups of workers expressly exempted by Congress, they plainly come within the broad statutory definition of employee." That's a quote from the case.
But that's Part 2A. You got to go to Part 2B.
Well, let me hang on. Let me tell you some people who went to both parts and couldn't disagree with you more. Everyone else who looked at this question, the administrative law judge, the National Labor Relations Board, including Republican appointees, 2 appeals court judges, including 1 Republican appointee, followed the Supreme Court precedent and came to the opposite conclusion that you did. I understand you may have preferred the Shurtan dissent, but you failed to follow Supreme Court precedent. This was a case where the National Labor Relations Act included those who were undocumented who could unionize to protect themselves in the workplace. You went out of your way to dissent all the way along and make sure they didn't, or in your view, not have that right, that they did not have that right to unionize.
I very respectfully disagree, Senator. And the reason I disagree is that the Supreme Court did say that the immigrant was covered under the definition of NLRA. If it ends there, I'm with you 100%. But then the Supreme Court goes on to say, and we consider also in resolving this question the conflict between the National Labor Relations Act and the immigration laws, and makes clear, as I read it, if the immigration laws had made employment of someone here in the country unlawfully illegal, then that would be prohibited in the case. And I went back, like I said, if you look at Justice, I quote the oral argument transcript from Shurtan in my dissenting opinion. I have no agenda in any direction on I'm a judge, so I'm just trying to resolve the precedent.
Well, let me close by saying this. I'm just a judge. I just follow precedent. Gosh, we've heard that so often, and I hope it's the case, but we know that there's much more to your job than that.
I agree.
The fact that you were a dissenter and everyone else saw this the other way should give us pause when you say, I'm just following precedent.
Well, I respectfully, Senator, that opinion, I'm proud of that opinion because I think it carefully details the law in that case. I'm following the Supreme Court precedent. And to your point that other judges disagree, there was a case I had about 10 years ago or 8 years ago called Papano. It was a case where I ruled in favor of a criminal defendant on a restitution matter. Every other court beforehand disagreed. I wrote the majority opinion with Judge Edwards and Judge Griffith. Every other court after us disagreed. Finally got to the Supreme Court this year in the Lagos case, and they agreed with our one opinion, the Papano opinion. Just to point out that just because other courts of appeals might have disagreed does not necessarily mean we were necessarily wrong, because the Supreme Court ultimately decides that. I understand your question. I appreciate them. Thank you.